We've welcome to everybody that's already joined us. We're almost 400 participants. There are 500 people registered to join us today. So, but I'm going to get started because there's quite a lot to cover in the time that we've got available. Welcome. It's really lovely to see so many familiar names on the delegates list. It's lots of friends and colleagues joining us today, probably with one of the largest events we've had in Chambers, but it's rather strange not to be able to see you all. So we can't see you. I hope you can see us and hear us okay. For those of you that know me, I'm Kuljit Bhogal. I'm a public law barrister in Chambers and I jointly head up the housing team. And with me are Andrew Lane and Sam Fowles, also members of the public law team. And together we're going to be presenting today's seminar. Just so that you know, we are at capacity, and if you've had colleagues that wanted to join that weren't able to join, we are going to try and record the webinar in order to be able to make it available after today. So do let those of you that have colleagues that wanted to register and join and haven't been able to, that's going to be something we're going to try and sort out afterwards. We are also going to share the slides with you afterwards, so if you would like to have a copy of them, then that's going to be available to you and save you having to do too much scribbling while we're speaking. We're really pleased to be able to offer this. It's a fantastic way to share our knowledge and intel on how we've been dealing with some of the issues arising since we've had the lockdown. And we've had lots of questions in advance of today, and we're going to try and answer those as we go along. But there will also be an opportunity to ask questions at the end and some dedicated time for questions and answers. We've also enabled the Q&A function on the webinar. So if there are questions that you would like to have answered, they're going to be a facility to be able to ask them in the Q&A. And depending on how many likes we get for the questions that are asked, we'll endeavour to answer the most popular of those questions. We might not get through all of them, but we'll do our best to get through as many as we can. So do bear in mind the Q&A function. In terms of what we're going to cover today, as you know, we're going to cover the changes to the rules for notices in relation to possession proceedings. That's going to be Andy. Sam's going to cover the cases that are currently receiving priority in the courts. I'll then look at injunction applications and then hand over back to Andy, who will look at social housing fraud before we have a questions from the audience session. But before we make a start with the actual content, I thought we'd do a short poll just to gauge with those of you that are participating, how many of you have actually had any hearings, what type of those hearings are, and we thought it might be of interest to the others that are participating. So there are 4 questions, and I wonder if you could take a moment or two just to go through those and answer those. And Sam, if you could let me know when we're ready to move on. Sam, can we see the next 2 questions? Oh, if you scroll down, you can see all 4 of them.
Just to explain how this is working, I'm able to monitor the poll, so I'm seeing who's voting and what's going on right now. Although your voting is anonymous, I can't see what particular person is voting for each thing. But I'll be able to see when the poll's complete, and I can see we're about 2/3 done right now.
Thanks, Sam.
I can see we're pretty much completed on the poll. So I'm going to end that now. Kuljit, would you like me to publish the results now or later?
I think it might be interesting for us to see what the results are now, and then we can perhaps that can feature in the rest of our session.
Okay. And we should have the results now.
Fantastic. That's pretty much what I was expecting. I have to say that certainly I've been hearing that reports of antisocial behaviour have increased, and that people haven't yet sought much in the way of injunctive relief, but are wanting to know what their powers and options are that are available to them. Did either of you have any observations before we get started on the seminar itself?
I would just comment on the less notices. A third of the people said they had served less notices, which is quite interesting. I suspect, certainly with the antisocial behaviour, it's because of the other options such as injunctions and closure orders, but it's interesting there's been a drop in service.
Okay, excellent. Well, thank you very much for participating in the poll. That's really useful information. As I say, we're going to start with the changes in notices. So Sam, if I could ask you to move on to the first of Andy's slides, please. And I'm going to hand over to Andrew Lane.
Okay, thank you very much. Sam, if you can go to the first of the main slides, please. Notices is a big issue, but as you'll hear, it's a fairly limited question. And one of the reasons for that is that the government initially started talking about the need to prevent people getting evicted because of rent problems, and that people were going to have rent problems because they weren't going to be able to go into work and so on. And so people were wondering what they were going to do. And certainly people started thinking about whether they were going to change Section 89 of the Housing Act 1980 by giving greater scope to the court to deal with mandatory cases such as Section 21, whether they were going to amend the guidance in the protocols and such like. What the government in fact did on the 25th of March 2020 was introduce the Coronavirus Act, which you see the heading in front of you. But actually, as far as we're concerned with this section, we're only concerned with two matters. That's Section 81, and in reality, we're concerned with Schedule 29. And Sam, if you can go to the next slide. Because what the government decided they would do is that they would change the time periods in which notices had to elapse before proceedings could start. Now, this has caused some confusion, which I'll go on to in the next slide, but just for the moment, effectively what happened is that the 6 notices you see in front of you, that's the notice seeking possession, the introductory Section 128 notices, the Section 21 notice requiring possession, flexible tenancy notices under Section 107D, demoted tenancy notices, and notice to quit for Rent Act, and I stress that point. Whatever they were before, such as 2 months for the Section 21, or 14 days, or 28 days, or no days at all for the notice seeking possession, they have to give at least 3 months before court proceedings can be issued. But it was only in respect of those 6 notices. Say that I would stress that when you see that first circle, secure and assured notice seeking possession, that includes the absolute ground notices as well. So that's both the discretionary grounds, the traditional mandatory grounds, and the absolute ground notices. And Sam, if you can go on to the next slide, please. Now, there are some practicalities which most of you will be familiar with. There have been, because of those changes, new forms produced for Section 8 notices and new forms produced for Section 21 notices. But in reality, the question I've been faced with quite a lot is, well, what do we do in terms of notices we served before the 26th of March 2020? Well, the simple answer to that is that they are good notices. There is nothing wrong with them. They are, assuming that they were valid at the time, they can be used to issue possession proceedings, which of course Sam will deal with in the next section. So one doesn't have to be concerned about the fact that you've already issued a notice. It's a good notice if it was always a good notice. It's only going to be cases where you're going to serve afterwards that you have to then change the notice period from the normal 14 days, 28 days, or whatever it's going to be, to 3 months. The third bullet point makes a crucial point, and again, this is the question that keeps coming up, is that notices to quit are generally not affected by these changes unless we're talking about statutory or protected tenancies under the Rent Act. In other words, if you were serving it because you said the tenant wasn't living there as their only or principal home, it's the normal 28-day notice for a notice to quit, unless it's a monthly tenancy, in which it's a month notice. If we're talking about somebody who has regrettably died and they're the sole tenants, again, you would serve the notice at the premises, and if they haven't got a will and they're intestate, you would serve it on the public trustee and do the normal 28-day notice. In other words, it's only the Rent Act notices to quit which are affected by these changes. So the notices provisions are actually fairly simple. One of the practical problems, of course, is going to be a question of service. And a couple of the questions we had in advance of this seminar were asking that question about, well, how do we actually go about serving at a time of isolation? Well, the reality is that firstly, of course, actual service is good service. So if there's no dispute and the tenant doesn't dispute, they've got the notice, that is fine, however you served it. Secondly, most modern agreements, of course, would have provision in their tenancy for how service can be affected. In other words, if you complied with the method of service provided for in the tenancy agreement, that will be treated as good service. So if it says that you must serve by first-class post, that's how you serve it. Whereas it may be a practice in the past of actually doing personal service, as I say, if you follow the tenancy agreement and you continue with that, then that is going to be good service. If you want to try and affect personal service, then of course you can try and do so, but of course there are practical problems which in a sense I suspect Kuljit will deal with when talking about service of injunction orders and so on in her section. But as I say, it's probably not going to be necessary to do so. But I think what is important to note is that, first of all, we're talking about an initial 90-day period where this affects from the 26th of March 2020. But secondly, and again, this is one of the queries that has come up, it's not just a question of notices, which are fairly simple. It's a question of what impact does that have in those cases where there are review procedures. So, for example, with the absolute ground, the introductory tenancy and the demoted tenancies, they all have statutory review procedures, or at least as far as the absolute ground in respect of secure tenancies. And that hasn't been changed at all. So these amendments are purely to the time that must be given in the notice. So if you take the example of the absolute ground, section 83ZA of the Housing Act 1985 provides that you give 28 days notice normally, but that's now 3 months if you serve it on or after the 26th of March. The tenant then has 7 days to request a review. Now that's still the case. They have 7 days. That hasn't changed. And you're required to carry out that review before the end of the notice period. And of course, that notice period is now extended, which has given you a longer period to carry out that review. And although the days are slightly different for introductory tenancies and demoted tenancies, that's the case with those matters as well. In other words, the tenant obligations and the time limits in which to request a review and the time limits in which to carry out that review have not changed. They are the same as before. And I think when we come on to looking at the fraud at the end, I'll mention something about some of the fraud elements of notices to quit. But for now, that's what I wish to say on the question of notices.
Thank you, Andy. At this point, I take over, and I'd like to spend a few minutes talking about the cases that are receiving priority and how they're receiving priority. Just the essentially the mechanics of what's going to get to court in during the lockdown and what isn't. I'd like to kick off by explaining the approach that Her Majesty's Court Service is taking, and the general strategy here has been to consolidate the work of courts and tribunals into a a smaller number of buildings. The aim being to keep things ticking over for the essential or priority matters, which I'll come on to in a moment, but obviously with the by absolutely minimising exposure. The courts, therefore, have been the premises have been put into three classes. Some are open and staffed, and to the extent that anything can be continuing as normal during the lockdown, they are trying to continue as normal. Others are staffed but not open to the public, and the advantage of this is they exist to essentially progress the administrative aspect of proceedings, and then others are of course closed. The expectation, the presumption, if you will, is that hearings will be remote, and the term used is whenever possible. Of course, this is not always going to be possible, and a good example of where it's not more often than not been possible is closure orders. However, if a hearing can be dealt with remotely, then it should be, and it will be. Now, I was asked a question in advance of this. I'm not sharing the names of everyone who asked a question, but I'm going to try and refer to the questions that I've been asked in advance, or any that I see pop up in the questions window in front of me. I was asked about the mechanics of a long distance hearing, and essentially there are two possible options that are being used. The first is Skype for Business, and I think that's the one that's been used slightly more thus far. The mechanics of this are, in theory, should be very simple. You should be sent instructions by the court. So I know initially there was discussions about claimant solicitors having to organise this. The guidance is now that it should come from the court. The court should send you an email, and you should be able to click through that email to join the hearing. You don't need a Skype for Business account, but you do need a Skype account, and that's the free sort of account that you can just sign up for. If you've got this, then you will be taken through to the court's Skype for Business setup. The other option is the court service's own cloud video platform. And this is something that's come in relatively recently. Once again, instructions should be sent by email, and the theory is that you should be able to click through in the same way that you've joined this Zoom meeting. However, the advice is to use your Google Chrome browser. That's the browser that works best with the court services platform. And I know a lot of people, I personally, I don't use Google Chrome as my major browser, but I would recommend downloading it and just for a short time switching it to be your primary browser, so you'll be automatically taken to it. The key piece of advice given by Her Majesty's Court Service for this is that you should try and join early. And now there have been a number of stories of lawyers attempting to join hearings and actually joining the hearing beforehand. I think these are likely to be outliers, because when this is working properly, it's in essence a different room for each hearing. The court services have advised you to join early, and I suggest that you take that advice and not worry too much about joining about horror stories that you might hear on Twitter. Now, the approach that has been that's been taken by the court service in terms of what matters will actually be heard is a priority approach, but it's being updated on an almost daily basis. And so what I urge you to do is keep an eye on the courts and tribunals tracker list. And this shows, and it's updated every day, it shows which courts are open and at which times. In general, these courts and service centres which should be open will be open 8 AM to 5 PM on Monday, and Monday to Thursday, and 8 AM to 4 PM on Friday. Now, I received a question about where claims or injunctions should be issued where the closest court has been closed. Now, obviously the civil procedure rules require that you issue a claim in the court closest to the defendant. It's not been made clear in so many words how this should change, but obviously if the court closest to the defendant is closed, then my advice is to issue in the closest open court. And you should remember, of course, that courts have the power to transfer proceedings. So if your approach isn't accepted by the court, they have the power to remedy that quite simply. What I would suggest, if you're going to be issuing in the closest open court rather than the closest court, is to include a covering note explaining what you're doing. What things will be heard during lockdown then? Well, the matters that are given priority are divided into two classes: priority 1 matters, and that is work that must be done, and priority 2 matters, which is work that could be done. And these are fairly self-explanatory as to what this means. But you should also remember that these are updated daily. And the link is posted on the slide in front of you. So it's all whichever day that you're planning to issue, it's worth checking the daily update. This is the update for today, and this was posted for this morning. And you can see the different groups of priority 1 and priority 2. This comes as a PDF, and essentially a new PDF is put online every day. Do not be caught out. This is a fairly prosaic tip, but important nonetheless. They don't take the other PDFs down. If you end up just Googling court listing priorities, there's a good chance that you'll get one that's out of date. So make sure you check the dates before you rely on it. Priority 1 matters right at the top, and I've been monitoring the daily priority lists for a couple of weeks now. The top of all of them has been committals. Now, I was asked a question about the practicalities of committal action, and one was how is an affidavit to be arranged for these. Now, I reviewed the civil procedure rules and the practice direction for an affidavit. On that review, I couldn't see, it didn't seem to me that there was a practical obstacle to witnessing an affidavit over a video link. However, when I read around the subject a little bit, it seems to be that the prevailing view, and certainly the view of the Law Commission, is that as at the moment, affidavits must be witnessed in person. That is obviously challenging and during the lockdown. However, of course, the lockdown regulations permit travel if it's for work, and under the umbrella of if you have a reasonable excuse. I think a solicitor travelling to witness an affidavit would almost certainly be considered a reasonable excuse. And of course, distancing measures can be put in place. Certainly haven't read anything to say that that you can't witness something from 3 or 4 meters away. I'm not going to go through each of these priority matters in turn, but I will just draw your attention to a few of them because they're relevant for what Kuljit's going to say in a moment, and that is antisocial behaviour, harassment injunctions are on there. There's a real emphasis throughout the priority 1 items on the sort of antisocial behaviour, protecting people during the lockdown, and matters that are going to be essential to do this. Now, it's been asked whether or how to get a warrant for bailiffs during the lockdown, and I did just want to draw your attention both to the previous slide, because that's it in official terms, and you'll notice when it mentions antisocial behaviour injunctions, it says not ancillary to possession, and it also notes that matters where a bailiff is not required are going to be prioritised. So while injunctions are being prioritised, it seems that anything involving a bailiff will not be prioritised. Of course, the priority 2 matters are listed here. Again, I don't want to take you through all of them, but I do want to just draw your attention to 2 things, and these are that the priority system it seems to be designed to encourage matters to progress wherever possible, particularly where the court is not required. And a question was put in advance, and that was about if a matter has been stayed but directions agreed, can those working on it continue working on the case so it's ready to go when the lockdown is over? And I think the answer to that must be yes. And indeed, I think that's likely to be beneficial when the lockdown ends and the stay is lifted, to be good to go as quickly as possible. Obviously, we've had no indication of how the backlog will be prioritised once the lockdown ceases to be in effect, but I think I can go as far as to say that being prepared to go won't do you any harm. I'm now going to hand back over to Kuljit, who will deal with the matter of injunctions in coronavirus.
Sam, before you do, can I just make mention of one thing that I've experienced, and that's in relation to pre-trial reviews. I mean, I've got one on Friday, for example, in central London, and certainly the feel I get is that the courts are quite keen to get on with matters as far as they can. As you've said, Practice Direction 51Z stops possession proceedings unless directions are agreed between the parties. But ancillary matters, so for example, on Friday we're talking about an Equality Act damages counterclaim, a disrepair counterclaim, and within the injunction, within the main claim, an injunction as well as the possession. The court's going to have to decide whether to proceed on those matters at the listed trial and shelve for the moment the question of the possession action. So certainly as lawyers and as practitioners, I still think there's a lot of work to be done as to what can proceed, whether that be by agreed directions or even by the court moving the possession side of matters to one side if there are more than one issue, and dealing with the other factors that you may have in a claim.
Thanks, Andy. I think that's a really important point to make. Right, I'm going to hand over now to Kuljit to talk about injunctions.
Hi there. So as Sam says, I'm going to be covering injunctions, and I can see from the live Q&A that a number of the questions relate to injunctions. I can tell you already that a number of those are already covered in the slides, but insofar as they aren't, I will endeavour to answer them as I go or at the end of my session, and will invite Sam and Andy to contribute if they've got any views or any experience of what's been happening during lockdown. If you could move the slides on, Sam, what I'm going to cover are the test for making an injunction under the 2014 Act, and just to have a quick look at some of the words and the case law relating to the test, because it's relevant to whether or not we can use the test in a slightly broader way now. Going to look at service, because that's obviously an issue in relation to personal service at least. The availability of exclusion clauses, and then how you can present your evidence, use of electronic signatures and affidavits. So if you could move the slide on, Sam, the first matter, just to set the context, is to reiterate what Sam's already said, and that is that civil courts have got 2 levels of priority in terms of work that must be done and work that should be done. And there are a couple of things I wanted to highlight here, one of which Sam has already highlighted in relation to the fact that committals and injunction applications that are ancillary to possession applications are considered priority 1 work. And so they ought to be being listed by your local court and being heard by your local court. And if your local court is one of those that's closed or is operating on a staffed basis only and is closed to the public, you ought to issue your application at the nearest next available court. And indeed, Andy and I were having a conversation earlier that it is 1 county court. So in theory, you can issue anywhere, and once you've issued, the claim can then be transferred to the defendant's local court. Or indeed, in the current climate, the need for transfer is less immediate, because of course, if the hearing is going to be by way of a telephone or video hearing, that can be with the judge that's sitting anywhere. And there are some judges that are still going into court and conducting telephone or video hearings from court. There are others that are doing them from their homes. So injunctions and committals are being heard, as are ASB injunctions and harassment applications that aren't ancillary to possession actions. And I know that a number of you have said, well, either my local court's not issuing, or I'm struggling to get any traction with my local court in terms of trying to get them to issue and then list something for hearing. It is simply about relationships, and if you have somebody you can contact within the court to ask them what they want from you in order to progress something, that's what you should be doing. And if you don't get any joy with that particular court or that particular individual, it might be a case of having to look at another court in order to get your application issued. It's also worth mentioning that the magistrates' courts are still sitting, and in particular I wanted to highlight the existence of closure orders on the magistrates' courts priority listings, because closure orders are still available. It's not clear to me why it's limited to police-led closure order applications, but that is the limitation at the moment. And I don't know if any of you have had experience of trying to issue a local authority closure order application. If you do, I'd be interested to know through the Q&A. But insofar as you're seeking a closure order in your local authority, normally you'd be able to do that in your own right. But at the moment, the limitation is on the police. For housing associations, they would normally liaise with the police or their local authority, and at the moment you ought to be liaising with the police in order to get your closure order applications listed. I've put an asterisk there because there is, throughout the information that the government's issued in relation to lockdown, a real reluctance to see people made homeless, whether that's through bailiffs enforcing possession orders, whether that's through possession action. However, this particular case, there's a judgment on it. It relates to an injunction that was used to require MB to give up possession of her hospital room because they needed it for COVID patients. And it is a way in which injunction proceedings have been used to, in effect, bypass the need for possession proceedings. I wouldn't start thinking, well, that's something we could use in all cases. It was a rather unusual set of facts, but it is possible to use injunctions in imaginative ways where there might be other limitations on seeking possession. Always, of course, one has to consider that the statutory test has to be met and that these circumstances justify the issuing of an injunction. So in terms of the test, if Sam, you could move the slide on. I've said here that the test hasn't changed, and so this test will be familiar to many of you, but just to set the context of what's going to come in the next slide, we've got to establish, for the purposes of section 1, the existence of antisocial behaviour, and that can be defined as harassment, alarm or distress, or conduct capable of causing a nuisance or annoyance. I'm not going to deal too much with the housing related aspect of it. And if one looks at what those phrases mean in a bit more detail, turning to the next slide, I've set out there a couple of extracts from my book, Cornerstone on Antisocial Behaviour. For those of you that have got a copy, there's a case called considered the meaning of harassment, alarm and distress for the purposes of the Crime and Disorder Act of 1998 in the context of ASBOs when they still existed. And what's quite interesting about what the court said there is that it's not that there's a distinction between activity which really frustrates and causes disappointment and activity that goes beyond that. And it says that for the purposes of the CDA, that same terminology, harassment, alarm or distress, is intended to catch action that could be globally described as causing someone to fear for one's safety, rather than frustration at the delay of a train. So if one thinks about what those words mean, fear for one's own safety, I think they have a particular connotation in the current climate, because of course the failure to adopt social distancing, the continued existence of gatherings, the barbecues that are being held on communal areas of land, and behaviour of that sort, it seems to me that that would be caught by a fear for one's own safety, because if that behaviour continues to occur, there is a risk in terms of the particular risk caused by COVID-19. It's not the same as somebody being fearful that they might get the seasonal flu. We know that COVID-19 is a particularly lethal condition. It's a lethal virus, and so I think that in appropriate cases you would be able to make out a fear for one's own well-being and personal safety in a way that we might not normally have considered were we not in this lockdown situation. So I think it is possible to look at the phrase in a slightly broader way in view of the current situation we find ourselves in. And then on the other side of the slide, I've got the nuisance and annoyance test. It's quite an old case, the Todd Heatley and Benham case. But again, it's worth reminding us that it's something, annoyance is actually quite a low threshold. It's something that reasonably troubles the mind of an ordinary English inhabitant of a house. So it's a low threshold. Again, we've got to be sensible about how we deploy our powers to seek injunctions as practitioners, but it's worth bearing in mind that I do think that the powers are flexible enough to be able to be used not only in our routine ASB cases that we see day in, day out now and even before COVID-19, but also in specific COVID-19 situations relating to social distancing and the like. So it's worth just remembering the test. It hasn't changed, but I think we can interpret it in a slightly broader way. So in terms of its application to COVID-19 related behaviour, on the next slide, I've got some examples of the types of things that you might be able to apply them to. Thank you, Sam. So public health concerns, clearly this is about one's well-being and about catching it, particularly if you're somebody that's got underlying health conditions or is otherwise shielding. I know that the advice is to stay at home and not leave your home, but not all of us have got the ability to adopt that all of the time. There are going to be times when you need to access the supermarket, the bank. There might be other urgent things that you need to do and you don't have the ability to get other people to do it for you. And there is going to be a genuine health concern for some people. And I think it's particularly true of those people that live in places such as sheltered accommodation, where there may be people there with underlying health conditions and they are having regular visitors, or that there are families mixing when they shouldn't be, because the requirements from the government are very clear in terms of staying at home and keeping that 2-metre distance. And so insofar as there are those public health type concerns, or there are gatherings that are repeated, or obstructions of entrances or communal areas, and this is one of the things that's come up on the questions today and also in advance of today, I think it is worth us looking at using our injunctive powers in order to control those types of behaviour. That's not to say one goes to injunctive relief first off. As we all know, this is a staged approach to behaviour management. And what I've put on the slide there is I think it is worth reminding our tenants of terms and conditions of their tenancy, and the fact that many of them live in, conscious that those people that live in high rises may or may not have access to any open space. They may not have a balcony. And so in relation to that situation, it's worth reminding our tenants that there are terms and conditions of their tenancy, and there are actions that can be taken if they don't abide by those terms and conditions of tenancy. And if you're experiencing particular problems with communal areas, and whether it's obstruction of communal areas or barbecues on the lawns or whatever it might be, is to perhaps do a block letter reminding all of them that these are requirements that we all need to abide by in order to ensure everybody's personal safety. So worth reminding people by way of a letter or a verbal warning, a phone call, before one looks at injunctive relief. But I do take the view that injunctive relief is available in appropriate cases and is worth bearing in mind. I think it's also worth bearing in mind that people need to know that they can still make a complaint, whether it's of the usual types of antisocial behaviour that we see outside of the current climate we're in, or whether it's COVID-19 related behaviour, that there are ways of reporting that behaviour and what those methods are, and that those reports are going to be picked up and considered, and that there are powers available to us to be able to enforce and deal with the behaviours that are being complained of, both as a comfort to the victims of the behaviour, but also hopefully as a bit of an incentive to the perpetrator to pull it in a bit in terms of the behaviour and some of the excesses of that behaviour. So in terms of some of the practicalities, if Sam, you could move on to the next slide. I've dealt with service of applications and of orders. So as we know, the position is that we are required to serve both the claim form or the application and any order that's made by the court. And a person can't be committed for breach of an order unless the order has been served on him or her. And clearly there are problems when personal service can't be effected because of social distancing rules. And I know from talking to a couple of my solicitors that even the process servers that were early on still operating are now no longer operating and aren't prepared to go and effect personal service. So there are things that you can do in relation to looking at how you can serve both the application and the order. And I've set out there that in relation to the claim, CPR 6.15 says that you need a good reason for the court to authorise service by an alternative method. So given the situation we're in, I'd be very surprised if the court felt that serving by alternative means wasn't a good reason, given the requirement to keep a 2-metre distance. So I think that there is a reasonable prospect that you'd get permission from the court to be able to serve in alternative ways. And I've set out there some of the examples of how you might do that. It might be a letterbox, it might be postal, or it could be WhatsApp or Facebook Messenger. You could adopt the kind of methods that we would normally use for trespasser proceedings in terms of sticking notices to a door or to some other conspicuous place where you think it will come to their attention. And what you would do in your application to the court is to make clear the ways in which you have served your application and get the court in effect to retroactively authorise those methods of service, and to say that those methods that you have used are good methods of alternative service, and also to provide permission for you to serve any order that the court makes by alternative means, and they could be the sorts of things that I've listed on that slide. I think WhatsApp and Facebook Messenger are particularly useful, not only because they are used by so many people, and a lot of people have access to those sorts of things on their phones, but also because you can tell from WhatsApp and Facebook Messenger whether or not someone's read your message. And if you're able to provide that sort of evidence to the court to say, well, this is when the message was sent and this is when the blue ticks appeared to say that the image or the text message or whatever it is has been looked at, I think that would be useful. And in the event that you have a committal application, that you would be able to rely on that sort of evidence to say this is what shows us that we think he's been properly served. But the important point is to get the court to endorse and approve any methods that you've already used to serve your application or claim form, and then to ensure that going forward any methods of service are approved and that alternative means of service have been asked for when you ask for your injunction application to be looked at by the court. I've also put on that slide that you can still apply without notice. The changes to the rules on notices and the like in relation to the possession proceedings haven't affected whether or not you can apply without notice, but of course you have to have reason to justify going to court without notice, and I'm going to touch on some of the authorities in relation to that. So that's service, and that deals with some of the questions that we've been asked in advance in relation to service of applications and of orders. And I'm going to move on to look at exclusion clauses. simply because this goes to some of the questions that have been asked around possession proceedings, and is this in effect a way of making somebody homeless, but through a backdoor route. The simple position is that there has, as today's date, there has been no guidance or other information issued by the government to suggest that there's any impact on the availability of exclusion clauses. So exclusion clauses are premises to be excluded from premises where there is a use of or threatened use of violence, or where there's a significant risk of harm. And so that's the test that needs if you want to seek an exclusion order, and you can still do it. But as I've said, bear in mind the guidance from the moat housing case. It will be very rare to get an exclusion clause without notice, given the current climate and the advice about staying at home, in my view, a court will be more willing to give you an exclusion zone, exclusion clause, if you're able to show that the defendant has somewhere else to stay, and the behaviour really does have to be bad enough to warrant it. But you can still do it, and it's worth bearing in mind in your injunction applications for situations where it's justified. So moving on then, presenting your evidence. I know I'm moving at a fair speed, I know, but we've got a fair bit to still get through. So presenting your evidence on the next slide covers some of the issues we've been asked on the questions in advance. If I could ask you to move, thank you, Sam. So diary sheets. One of the issues is in relation to, well, how do we get people's evidence of behaviour to us? How do we, normally it would be a diary sheet that issued, the housing officer would go along to collect the diary sheet, and then that would be exhibited to a witness statement. Well, we're not in a position to have that level of personal contact with people, but that's not to say that they can't still keep a record, and they can do it in a written form, a handwritten form if they want to. Equally, they could do it in a Word document that they email to you. And again, the advantage of something like WhatsApp is that they're able to take images of those notes and email them to you or WhatsApp them to you. And I've also said that it's worth thinking about having an online system for reporting things if you think that will be beneficial for your tenants. So there are ways of dealing with this that are sort of imaginative, and will still make sure that the quality of evidence is still available to court in relation to the complaints that are being made by your tenants. So worth bearing in mind. Signatures, we've had a few questions on this. The position is really straightforward. CPR 5.3 allows electronic signatures. So what that means is that you can type your name into the space where there is provision for a signature, and that is adequate for the purposes of the requirement that a document is signed. And so that ought not to present any obstacle as far as signatures are concerned. You should all be able to do that all over computer, over email. Affidavits, I've said there that committal applications still require affidavits, and Sam's quite right to say that CPR 81.10 is where you find the requirement for affidavits. What I've suggested is that when you make your application for your injunction, given that there are problems with seeking to get a solicitor or a court to sign off on an affidavit, which would normally be the place you go to get the signature witnessed, if those options aren't available at an appropriate level of social distancing, it seems to me that the most practical answer is to ask the court for permission to use witness statements instead. And the court's got the power to make that as a direction as part of its case management powers. And you could preempt it by asking for that permission in your injunction application. So when you apply for your injunction order, one of the orders that you might want to apply for is to say that in the event that there is a committal application issued in respect of this injunction, that it would be adequate for that committal application to be supported by a witness statement evidence as opposed to an affidavit. And it seems to me that that's a straightforward way of dealing with the situation of not being able to have affidavits witnessed. Where you've already got orders that are now being breached, so these are old orders that you're having breaches of and you want to issue a committal application, we know that the courts are dealing with committal applications, and what I would do when you make your committal application is simply ask for permission to rely on witness statements as opposed to affidavits, and a short explanation that the COVID-19 restrictions mean that you're not able to have your witness statements witnessed in the same way, or your affidavits witnessed in the same way. I think it'd be very unusual for a court not to accept that, given the current restrictions. We won't know how well it's working until it's been tested, but it seems to me that that would be a sensible way forward. And I know that the Law Commission have been working on looking at removing the requirement for affidavits altogether, because there does seem to be a bit of an anomaly in relation to the CPR, where everything else is witness statements. That hasn't happened as yet, so that requirement for affidavits exists. But it seems to me that there is a straightforward way of being able to bypass that and use witness statements instead, and that's what I would suggest that you do. So in terms of the checklist of things to ask the court for, if we could move to the next slide. What I've suggested in the next slide, Sam, is that we communicate with your court to ask what they want from you and by when. And I put there, ask about the format of bundles, the format of the hearing, whether it's by telephone or video. Courts are already geared up to deal with telephone hearings, and many courts already do hearings by telephone. And very often that will be a case of using something like a provider like BT Connect, or one of these external providers that you provide the phone numbers to, and they connect you all together, and they ensure that the call is recorded for purposes of court service being able to have a record of the call. And so that side of things is fairly straightforward. Where there's a need for video evidence hearings, Sam's already dealt with some of the ways in which the courts are dealing with those. Bundles we haven't touched on, but it's worth just thinking about some of the what's circulating in relation to bundles. The requirements seem to be that you need a single PDF bundle. And with the hearing I'm doing in Manchester on Friday by telephone, what the order says in that case is that the bundle has to be of a maximum size, and I think it's 10 megabytes. So there might be some restrictions on the size, simply to allow things to get through by email and be opened. But they're asking for a single document, so your documents need to be stitched together, as it were, in a PDF bundle. And in Chambers we've got the technology to be able to do that. So if you're struggling with that and need some help with getting your bundles prepared, then speak to our clerks, because they may be able to offer you some assistance in how to get that done in an appropriate format. I've suggested there that you dispense with personal service, or you apply for permission to dispense with personal service, and to allow service by alternative means, both for the application and the order. A third point that we haven't yet covered is that in a court building, and that means that can do it from his computer. The judge may not have the ability to seal the order, and so it's worth thinking about asking the court to include a clause that says that the issues about the actual stamp not being available when the order is made, and finally seek permission to issue committal applications using witness statements and not affidavits. And I just want to touch on some of the Q&As that have been asked in relation to injunction applications before I hand over to Andy to cover the last bit of session, and that's in relation to gas servicing and electric servicing. Particularly for people that are shielding, the position is that it's very unlikely that you're going to be granted access for somebody that's shielding, because by the very nature they're in a high-risk group. And certainly the Gas Safe Register and others are advising their operatives not to enter properties where people are shielding, and to arrange for an appointment after the 12-week shielding period is over. So there isn't any, as yet, there aren't any regulations or guidance that suggests that the timelines for the annual servicing have been relaxed. They haven't. Unlike MOT, where we've had some relaxation, we haven't for electrics and gas. But at the same time, one needs to employ a case-by-case sensible approach. So if there are cases where there is a higher risk because of an escape of gas or some other reason why you think the property is at high risk, those are the properties where you might want to go to court to seek access. However, for the vast majority of cases, what you're going to be doing is writing to someone to say, can we have access? If we can't have access, can we arrange access for a time after lockdown has been lifted? Because although the government has said that certain works can still take place if social distancing can be adopted, one can well see that that's quite difficult in relation to the way in which some properties are organised and the numbers of people that might be in occupation of them. So you have to prioritise your cases and deal with them on a case-by-case basis. And it's very difficult to see you being criticised for failing to do an electric or gas safety test in the event that the reasons are because the occupants were shielding or because your operatives couldn't employ social distancing measures. So that's some of the answers in relation to gas servicing and electric servicing. There's a sort of theme of questions around, can we use the ASB powers given that there are specific powers in the Coronavirus Act? And it seems to me that the simple answer is yes, partly because many of the powers in the Coronavirus Act have been granted to the police as opposed to the local authority. And so in circumstances where the local authority is experiencing issues and the police either aren't willing or able to act, then there's no restriction on you using the 2014 Act powers in order to be able to deal with the measures, so long as the test within Section 1 is met, namely the existence of antisocial behaviour. And I've already covered the way in which I think we can deal with that in a broader way in the current climate. So those are the matters I'm going to deal with, partly because I'm conscious of time. We're at 3 o'clock. Sam, if I could ask you to move on the slides. There's more information available in the book, which is also available in an ebook version. And if Andrew could take over to deal with the social housing for it, please.
Thank you very much, Kuljit. Yes, we are at our limit pretty much, but I will hopefully not be too long on these sections. What I would also say is that there have been certain amendments today to the Act, in particular from Section 52, which may impact upon local authority powers, but I'm really dealing with the question of fraud. The first slide, Sam, if you go on to the next slide, is really just to reinforce the point that when we talk about legislation here, when we talk about guidance and direction, there isn't a great deal. We've already seen Section 81 and Practice Direction 29. We've already seen the fact that there are priority cases put up every day by the HMCTS. There is actually guidance on the court website and indeed on the Housing Communities and Local Government website as well about possession proceedings. So there isn't a great deal, and Practice Direction 51Z is a very simple direction, which of course was amended, as you've heard, on Monday of this week, to really make the point that injunction proceedings are still able to be proceeded with, as well as certain trespasser proceedings. But going on to the next slide, really what we're talking about here is that proceedings can still be issued. So we've already dealt with the question of notices, and that old notices, i.e. pre-26th of March, are good notices. Notices you've issued since that time, of course, haven't yet expired. But once they do, subject, of course, to what's happening with all this guidance and practice direction and regulation and legislation, there's no reason why you can't issue. And that even if at the time there is still a stay in force, so even if they extend it beyond the 90 days, there's no reason why you can't issue, although, as you can see on the screen, the courts very much would hope that you don't. There's no reason why you shouldn't, so that when the stay is lifted, hopefully it can get lifted as quickly as possible. And I've just made mention at the end something about trespassers, and that's largely in relation to commercial matters. But of course, when I talk about trespassers there, I'm not talking about a strict definition of trespassers. I'm talking what I would call true trespassers, people who've gone onto the land as trespassers. And injunctions, of course, are still available for those, and local authorities up and down the country are still using those particularly in the absence of the police and their guidance often being to not take any action against people trespassing on land and commercial properties. But going on to fraud, Sam, if you go to the next slide, what we're seeing here is from anecdotal evidence is that people involved in fraud work are often being relocated to other areas of work, and that's for fairly obvious reasons. There's obviously greater priorities, particularly for social landlords, and trying to assist their tenants and trying to deal with the question of rent arrears, etc., that are arising, no doubt. But also, of course, many of the actions of somebody carrying out fraud work are necessarily limited by the changes you've heard about already today. What I would say is that pre-action protocol letters are as relevant as ever. It's something that I am very keen on, very detailed pre-action protocol letters, whether it's an allocation fraud, a subletting fraud, or any other type of fraud. Those should be sent out as quickly as possible. There's also no reason why information can't be sought from third parties, banks and fuel suppliers, and of course local authorities have express powers for fraud investigation purposes under the 2014 regulations you see there on the screen. In a very proactive way, of course, there's also the possibility of email and telephone video conferencing, in particular in relation to would-be witnesses and colleagues in other agencies in terms of information which may proceed. I suspect caution interviews have stopped and necessarily therefore investigations have not been completed, but certainly on the paper, investigations should be able to continue. Go on to the next slide, Sam, please. And the next one. That's just a nice picture I found. It says later explanation, it meant earlier explanation. Sam's already explained about the priority of court work. Fraud work, in essence, isn't a priority court work, and that's the reality. In terms of the criminal side of matters, of course, that's covering urgent matters in both the magistrates' courts and Crown courts. Again, it's not necessarily seen as urgent work, although, of course, there will be time limits in terms of issuing your summonses in the magistrates' courts for the summary-only cases. But in terms of progressing the case, that is going to be difficult, and the reality is that that's unlikely to happen. And as you can see there, the Crown courts are clearly and understandably focusing on other matters at the moment. In terms of shared ownership, now shared ownership is one of those areas that people often get confused about because, of course, shared owners are assured tenants, well, normally assured short-hold tenants, and therefore there's always a temptation to treat them in the same way you would treat a periodic short-hold tenant if they have committed fraud or if they're not living at the property as their own, your principal home, and that's by way of a notice to quit. But of course, it's not that simple because they have a 99-year tenancy, and normally, if they're not living there as their own, your principal home, and if it's joint tenancies, neither of them are living there as their own, your principal home, and there's no marriage rights, the reality is that you're going to have to go through forfeiture proceedings. As you can see from the last bullet point, there's no restriction on seeking declarations of breach in the first-tier tribunal. That's still available. And there's no reason why you shouldn't apply for an injunction to prevent the breach of tenancy in respect of the shared owners. But further than that, it's going to be difficult in terms of any possession proceedings that there are to follow for exactly the same reason as any other possession claim. It would be a Part 55 claim and therefore stayed by reason of the Practice Direction 51Z. I think the reality is with fraud work is that it's going to be limited. You may have seen on the Cornerstone social housing fraud Twitter account today, there's a report of a solicitor who was struck off for committing housing fraud. And if you move on to the next slide, Sam, you will have seen perhaps the fact that somebody was sentenced by Skype. So that didn't break up. And they were sentenced because of their housing fraud. And in the normal way, they get a suspended sentence and a fairly limited cost order against them as well. So that form of work is still happening. But the reality is the staffing isn't there in the same way as it was before. The investigative work can continue, but the work which would involve going round to properties, speaking to people, trying to speak to the tenant, trying to speak to whoever's occupying the property, is clearly and understandably not happening for obvious reasons, and social distancing being the main point there. But it is still available. If the evidence is there, proceedings can still be issued. And in theory, one could, I suppose, argue that you could go for something like an unlawful profit order on its own. My concern about that, I'd have to say, is twofold. One is there is a question of, well, does the tenant or ex-tenant have any money? And secondly, there's a question of would it be treated as some sort of estoppel if you thereafter sought to get possession proceedings issued, in the sense that they should have been issued at the same time as the unlawful profit order. But in principle, one can seek money claims as before. So that's all I really have to say on fraud work. It is still happening, and it is more limited than it was, and that's a shameless plug for the book. But more importantly, I think we do still have some questions and answers, and I've certainly seen some, Kuljit, coming through the system, and I don't know how many of them have been answered and how many people are wanting to ask extra ones. I don't know if you've been able to get a feel for that.
Yeah, so what I've done is I've tried to tick off the ones that I think we've answered on the Q&A, and what I was going to suggest is that maybe each of us take one area, given that we are now over time, but if we each take, say, one question which has been the most popular or where there's been a theme on any of the areas. So if you want to answer a question on injunctions, feel free. Clearly, we all practice in all of these areas. So perhaps if I could kick off with you, Andy, is there anything that you'd like to deal with that's been a bit of a feature on the Q&A or in the questions that have been answered in advance?
Well, I think a lot of the questions are about the practicalities, in particular of injunction proceedings. And I'm looking at one, for example, from Anita. It's got 7 likes at the top of mine anyway. It talks about, we applied for without notice injunction last Thursday afternoon and are still waiting for a court hearing. And it's a case of a resident causing an issue in sheltered housing scheme, proportionality completed. I mean, it is, as I say, a practicality question, and there are other questions, for example, about what do we do when we've issued in a court that's now closed. One person said that they had to reissue and pay the fee again because the court is now a closed court. It seems to me that, and it's not particularly helpful in terms of an urgent matter, but each of these courts have regional courts, and obviously they can be contacted in terms of their operation of these matters. But there is a genuine difficulty because contacting the court before this crisis was difficult enough. They haven't opened up the system to make it easier. Where I would praise the court service is that where hearings are being listed, and this is again another question about what do we have to do in practical terms, I found it very useful, and the court's been very helpful in sending out an order making it very clear what you need to do. Either press on a link which will be sent out, or your solicitors need to organise it. It's very helpful in that respect. But it's one of those cases, I'm afraid, where there's not an easy answer. It is about trying to contact the designated civil judge, which of course for London is His Honour Judge Luper QC, if there are any problems, and hoping he would deal with it through the proper system. But it's not an easy answer. It is an important matter. There are urgent injunctions, but some courts are better than others.
I'll jump in now if that's okay. There's a number of questions were asked about the whether reference can be made to the guidance that I mentioned, and whether we can send out links. The answer is yes. The links are all in the PowerPoint presentation, which, as we said, will be put online afterwards. So the links are all there. And just to be clear, if the court has already directed you as a solicitor for one of the parties to organise a hearing, then you of course have to follow the directions given to you in your case by your judge. Things that are written on a website don't override directions that the judge has given you. There are a lot of other questions that I've seen that all relate to very sort of specific sets of factual circumstances and some specific sets of legal circumstances. these are things that we'd obviously encourage you as solicitors to approach us directly to deal with, because I think this forum is only really appropriate for dealing with more general questions. That's the big one I wanted to highlight. I'll hand it over to Kuljit again.
Thank you very much, Sam and Andy. I'm going to wrap up because I'm very conscious that we're running over time, but just two matters that I wanted to raise. One is that Ngozi from Tower Hamlets has got in touch to say that she has managed to secure a closure order, a local authority-led closure order in the Magistrates' Court, despite the Magistrates' Court's priorities showing it being a police-led closure order. So I think it's definitely worth an ask in your local court to see if they will entertain an application from you as a local authority. It doesn't seem to me that there's any real sense behind only allowing police-led applications and not allowing local authority-led ones. So that's one thing. And the other thing, just to highlight for those of you that might not know already, is that there has been a change to the statement of truth for witness statements. And just to flag that up for you, and if you are preparing your evidence, just to have a look at what the latest version of that is. I'm going to wrap up because we've run over time. Thank you very much to all of you for participating. I hope you found it useful. We will be publishing the details of further webinars, and I know that the housing team have been working on two in particular, one on the public sector equality duty and possession claims, and the other on the public sector equality duty and homelessness applications. And I'll also be doing 3 shorter seminars on CPN's closure orders and PSPOs, which are likely to be pre-recorded so that you can watch them at your leisure rather than having to log in at a defined time. You will get an email asking for feedback. Do reply, let us know what worked, what didn't. And in particular, if you could tell us whether you have any requests for further topics that you'd like us to cover. That's something we find really useful, and we'll try and tailor what we do to the things that you'd like us to hear about from us. There is also the ability to sign up to e-flashes on our Chamber's website for e-flashes and newsletters. And on this slide, you've got all the contact details in the event that you had any further questions. And the title slides within the presentation had our individual contact details if there were things you wanted to follow up with us on an individual basis. So thank you very much for joining us. As I say, we'll email the slides and a request for some feedback, and hopefully see a lot of you again soon.